All right. Hello, everybody. My name is Gabby. I am our Community Education and Outreach Coordinator here at Legal Aid. With us today, we have Alicia Suter and Daniel Linares, who are going to be presenting on criminal record expunction in North Carolina. If you're unfamiliar with our Listen and Learn presentations, the general format is that Alicia and Daniel are going to go through a PowerPoint presentation. Again, today we're talking about expunction, so that's what their presentation is going to be on. And then at the end, we're going to have a chance for a question and answer session. So what that will look like, again, we're going to have the presentation and then the Q&A. In that Q&A, we do ask that your questions remain general. A lot of times people will come in and say, well, I have this, and this charge. Are these expungible? And typically those are questions that can't be answered. And Alicia and Daniel, please correct me if I'm wrong. So be mindful of the types of questions that you're asking. This is a public forum too. This is going on our social media pages, as well as anybody in the Zoom can see your questions or hear them being answered. So be mindful of the information that you're revealing and the way that you're phrasing your questions. We'll do our best to answer anything and everything that we can, but some things are just out of the realm of possibility in this forum. With all that being said, again, we're going to have the presentation very briefly, and then we'll have a chance for the questions at the end. So if you're viewing on Facebook, your questions can go into the comment section below the video, or if you're viewing on Zoom, they can go into the Q&A box towards the bottom left-hand side of your screen. Again, on Facebook, your questions will go into the comment section below the video, or on Zoom into the Q&A box at the bottom left-hand side of your screen. With all that being said, though, I'll stop talking. I'm going to pass it over to Alicia and Daniel, and you guys can kick us off.
Thanks. So once again, my name is Alicia, and I'm a staff attorney here with Legal Aid, Second Chance Expunction Team. And with me is Daniel. I'll let him introduce himself.
Hello, everybody. My name is Daniel. I'm one of the paralegals from the expunction team here at Legal Aid.
And his camera is broken, so
yeah,
that's why you can't see him. Okay, so welcome to the presentation. Lunch and Learn Expunctions, Second Chances Are Real. Presented to you by Legal Aid. So Legal Aid of North Carolina, who we are and what we do. We are a statewide nonprofit law firm with local offices across the state, and we provide free legal services in civil matters and then expunction to low-income people who qualify in order to ensure equal access to justice and to remove legal barriers, to hopefully provide legal services to those that may not have them otherwise. Some of the areas that Legal Aid assist with are some employment, such as unemployment, appeals hearings, housing, such as evictions, education law, domestic violence, which is kind of like interpersonal violence, disaster relief, hurricanes and things of that nature, consumer, and expunction relief. So monthly Listen and Learns not only are offered for expunction, there's some other ones that include child custody and visitation, employee rights, healthcare, powers of attorney and living wills, a file it yourself, simple divorce, some social security disability, and tenant rights, which is the housing one. And you can register for those the same way you registered for this presentation today, at the website legalaidnc.org. Also, if you need assistance with any of these areas, in addition to applying on our website, you can call the helpline 1-866-219-5262, 866-219-5262. And then again, there's also online applications. And for the expunction team, the quickest way to get to us is to hit option 1 again, then 2, and then 3. So what is an expunction exactly? It's the destruction of a criminal record by court order, so that we'll get to what will show up and what won't, but for the most part, it will no longer show up on a person's public criminal record. So North Carolina Adult North Carolina criminal records are permanent and public, regardless of the outcome. No matter how small, like a traffic or infraction, failure to wear a seatbelt, expired registration or inspection, regardless if those are dismissed, they are still part of your criminal record for the public to see. All the way up to serious felonies. Expunction laws are very specific. They're also state specific. So if you are not here regarding a North Carolina state charge, then you would need to consult the state laws where your criminal charges and or convictions took place. And again, this isn't for federal either. Not all misdemeanor offenses and just a few types that we'll go over of felony offenses are eligible under state law to be expunged. However, once you do have expunctions granted, a person may truthfully indicate that criminal proceedings never occurred, especially on like job applications. So why are expunctions important? This number is much higher probably now, but many millions of North Carolinians have criminal records of some sort. Again, even if it's traffic infractions, every arrest comes with some sort of penalty or sentence, whether your outcome was a guilty or not guilty or dismissal. Again, it's all part of the public criminal record. So that's why we offer this presentation. Knowledge is power. Okay, so what types of things are eligible for expunction? In North Carolina, there's different types of expunction relief, and those are in the statutes, 15A, and then there's different ones on 15A. So requirements to obtain expunctions are very specific as laid out by the laws. And we use the word laws and statutes interchangeably. So most common expunctions are for dismissals. Acquittal is a fancy word for not guilty. Raise the age relief will explain more, but that's when there was offenses that occurred when a person was 16 or 17, so not quite an adult. And non-violent, violent we'll go over later. It's a term of art, so it's not just what you think as violent, but non-violent misdemeanors and some felonies. And again, violent being a term of art, those types of convictions are rarely eligible for expunction, and we'll explain more later.
Okay, I'm going to talk about the dismissals and acquittals and what charges qualify. In this case, any and all misdemeanors and felony charges that were resolved by a dismissal or a finding of not guilty and not responsible, they do qualify for expunction. Usually when you file this type of petitions, there is no cost unless the case was dismissed as a deferred prosecution dismissal, which usually will have a fee of $175. Usually when we do work on those cases, we add a waiver. It's called a petition to proceed as an indigent, and that allows us and the courts to pretty much waive the $175 fee that goes with it. Usually prior felony convictions were a bar for relief, but it's no longer the case. So that's why we say any and all dismissals are qualified to be expunged. They are immediately eligible for expunction upon dismissal. There's no waiting period for expunction of dismissed charges. So if the charge gets dismissed the same day, I would say just a few hours later, then probably you can file, or the day after, to expunge those dismissed charges. There is no hearing required anymore, and the relief is mandatory, except in limited circumstances. We'll touch bases on that later. There is a few examples that I want to bring. Example number one, on January 9th, 2005, the charge is manslaughter. It was dismissed. Example number 2, July 5th, 2017, possession of marijuana up to half ounce was dismissed. And on the same session of court, the person was convicted for possession of drug paraphernalia. And example number 3, December 5th, 2021, the felony larceny by employee was found not guilty. Later on, we're going to talk about what it means to have an initial charge or a charge that was dismissed in the same session of court as the conviction. But go ahead, yeah.
Okay, next up, I briefly mentioned this, so there's a statute called Raise the Age Relief. So what this means is expunctions of all misdemeanors. Later in the presentation, you'll find out why that's really important. That if a offense was, it's the offense date, not the conviction date. So an offense committed by 16 or 17-year-olds, all misdemeanors and class H or I felonies, and they must have been committed before December 1st, 2019. And there is an exception. Certain motor vehicle offenses, like a DWI conviction, whether you're underage or an adult, those are not eligible for expunction under current law. And anybody that's required to register as a sex offender, whether you're an adult or 16 or 17, those are not eligible for expunction. Okay, so in certain circumstances, especially convictions, there's usually $175 cost. And again, as Daniel mentioned, that can be waived by presenting a petition to proceed as indigent, letting the court know you can't afford to pay. And hopefully that will be granted and it'll be free to file. So here are some of the requirements for the Raise the Age relief. A person must have completed their sentence, whether that was some active jail time, probation, including unsupervised, any post-relief supervision, and they must have paid all restitution. So that is for the underage and the adults. Restitution must be paid. And no barrier to relief, meaning you can file as long as you've met these requirements. There's no waiting period like you will hear with adult convictions. No limit on the number of convictions that are eligible as long as they meet this requirement, and the relief is supposed to be mandatory. What that means is a judge is not supposed to have any kind of discretion in whether or not to grant this type of expunction. Here's a few examples. Monica was 17, convicted of simple assault. Then she turned 18, convicted of communicating threats and second-degree trespass, sentenced to 45 days in jail. Keep in mind, the most important thing to note is she was only 17 at the time the assault was committed. If she was an adult, the answer to this example would be totally different. So Monica's assault conviction is eligible for expunction because she was 17. And will not prevent any expunction of adult convictions. And then we have Trevor, who was 16, convicted of 5 counts of felony larceny by employee, and then 2 counts of assault on a female. He completed his sentence in 2009. So all of these charges are eligible for expunction because of the Raise the Age statute. He was 16 at the time the offenses were committed. Again, it doesn't matter the misdemeanor classification, and the felony larceny was a class H. And what we mean by that is the sentencing, the classification for sentencing. So there's A through I sentencing classifications. And then 3 through A1 for misdemeanors. Okay, we have a few more examples to go over. Marcia, 17, convicted of felony breaking or entering, and she pays all her restitution in 2021. Her conviction is eligible for expunction because this was a Class H felony. However, this would not be eligible for expunction until 2021 because that's how long it took her to pay off her restitution. Okay, then we have Brent, 2018, convicted of DWI and felony flee to elude, completed his sentence in 2020. His convictions are not eligible for expunction. Again, regardless of age, DWI convictions are not eligible for expunction under current North Carolina law. And certain motor vehicle offenses, in this case, he was convicted of felony flee to elude. Now, DWI, just real quick, DWI dismissals, those are eligible for expunction, but just not the convictions.
Okay, so I'm going to talk about expunction in general of convictions. In this case, expunction of adult non-violent misdemeanors and felonies. The current categories allow for the expunction of one non-violent misdemeanor conviction after 5 years. That's after 5 years of the date of conviction. There is a multiple non-violent misdemeanor convictions after 7 years. And those 7 years count from the latest conviction on that person's record. As far as felonies, we have one non-violent felony conviction after 10 years. And up to 3 non-violent felony convictions after 20 years. But that has to have
Daniel, we lost sound, I think.
Say that again.
Okay, you just need to repeat the last part because we didn't hear you.
Oh, you lost me there. Okay. Yeah, as far as the multiple non-violent felony convictions, it is only given in the case that the 3 felonies occurred within 24 months of one another, of all those 3 felony convictions. Now, I will be talking about these qualifying convictions and what we use the term violent, but it's just more like, what the law considers high-level offenses. In this case, for purposes of this section, the term nonviolent misdemeanor or nonviolent felony means any misdemeanor or felony except the following. We have Class A through G felonies and Class A1 misdemeanors. If a person has any of those classifications for the offenses, then there are disqualifying offenses according to this section. Any offenses including assault as essential element of the offense. That includes a simple assault, assault on a female, any offense that has the essential element of the offense as assault. Offenses under the Article 27 of Chapter 14, which is for prostitution, which require registration upon conviction. Any and all sex-related or stalking offenses. Possession with intent to sell or distribute cocaine. Felonies involving methamphetamines or heroin. Convictions involving racial intimidation, such as an example of cross burning. Offenses committed because of the victim's race, color, religion, nationality, or country of origin. Convictions involving contaminating foods or drink to render someone mentally incapacitated or physically helpless. These one changes, and I don't know if you want to explain that one, Alicia, since you're the attorney, about the breaking and entering.
Okay, so again, these, if you are convicted of any of these, then they are called disqualifying convictions, and that's as an adult. That's why the raise the age statute is so important. What we mean by disqualifying is not only are these types of convictions not eligible for expunction, but they prevent a person from expunging any convictions off of their record. Now, there was a brand new change in the law So previously, a person that was convicted of breaking or entering, even though it's a class, I think H felony, that was considered disqualifying. The law just changed where if a person is convicted of a single one breaking or entering or many breaking or enterings in the same session of court, instead of the 10-year waiting period for single felonies, 20-year waiting period for multiple felonies, they split it up and it's a 15-year waiting period. And if you have multiple breaking or enterings, as long as they're within the 24-month period, that would be a 20-year waiting period. So basically what it boils down to is breaking or entering is now eligible for expunction, where in the past it wasn't.
Okay. And to finish, thank you so much, Alicia.
Mhm.
And then to finish, any offenses that is an attempt to commit any of the above I listed before or stated before, they would also count as disqualifying offenses. Let me see.
I think it's me.
Yeah.
Okay. Single, non-violent. Again, we just described to you what's considered violent. So these are now non-violent misdemeanor convictions. This allows for the expunction of one non-violent misdemeanor conviction. Again, if you are convicted of several things in the same session of court, so maybe shoplifting and misdemeanor larceny on the same day, same session of court, then that counts as one for your waiting period. Here are requirements. No other convictions other than traffic violations. Otherwise, it wouldn't be considered one or single. No outstanding restitution owed. 5 years have passed from either the date of the conviction or when a person finishes their active jail time, their probation, whether supervised or unsupervised, whichever occurred later. Again, a filing fee which can be waived, and relief is supposed to be mandatory, meaning the judge is not supposed to have discretion in whether or not to grant this type of expunction. And then we have multiple nonviolent misdemeanor convictions, meaning you were convicted of more than one misdemeanor in different sessions of court or different years, different months, different days. Instead of a 5-year waiting period, there is now a 7-year waiting period. Now, the waiting period clock starts either the date of conviction if you happen to not have a sentence of any kind, or 7 years clock starts at the completion of your sentence. So that would mean when you got out of jail or prison, when you finished your probation or unsupervised probation. So if you were convicted in 2020 and you were given 2 years probation, you would not start your 7 years until 2022. Again, you cannot have anything considered violent, which Daniel went over the list because those are called disqualifying convictions. No restitution owed. The filing fee of $175 can be waived, and relief is again supposed to be mandatory. The only time relief would not be mandatory is when a person is trying to expunge some dismissed charges, and well, that's with dismissed charges, but when you are trying to expunge dismissed charges and convictions in the same session of court, that's when things change. Okay. Then we have nonviolent felony convictions, which are treated a little bit differently. One nonviolent felony conviction, again, if it's the same session of court, like a forgery conviction and an uttering conviction, same day, one counts as one. Now we jump up to a 10-year waiting period. Same situation as the 7 years. The clock doesn't start until you finish your sentence, whatever that may be. And then nothing for the violent felonies. And one thing is even a simple assault or simple affray, unfortunately, no matter how long ago it occurred, is considered a disqualifying conviction. Again, filing fee waived, and here is the caveat that is different, with felonies, relief is discretionary, meaning the judge makes the decision whether or not they're going to grant the expunction of the felonies convictions. Next slide. If it works.
No, do you see it? I just flipped the page.
Oh, yeah, sorry. Okay. So now we're up to the multiple felonies. Again, as Daniel stated, there can only be 3 nonviolent felony convictions within a 24-month period. Multiple convictions, again, count as a single one within the 24-month period. So instead of the 5, 7, or 10-year waiting period, we now have 20 years, not starting till after the sentence is complete. And again, no disqualifying felonies or misdemeanors. The filing fee can be waived. And again, just like the single felony, relief is discretionary, meaning it's up to the judge as to whether or not they're going to grant the expunction. And these may or may not require a hearing.
Alrighty, I'm going to talk about some things to know. DWI, which is driving while influenced or under the influence, is no longer a disqualifying violent offense. Formerly, a DWI would prevent all other convictions from being expunged, but that's no longer the case. However, the DWI itself cannot be expunged. That's still the case for that specific conviction. Again, as Alicia mentioned before, the breaking and entering expanded eligibility. So now it is more flexible when it comes to those specific offenses. Automatic expunsions of dismissed and not guilty charges, that used to be a thing in like the beginning of 2022 or like late 2021, but it was suspended for now for some issues that they were causing, and I believe that was with the Department of Motor Vehicle. Now there's a 120-day rule for petitions to expunge convictions in different counties. They all have to be filed within a 120-day window. If, for example, you have a conviction in Wake County and another conviction in Durham, then you have to file within that time window. Otherwise, you may have issues with pretty much waiving one or the other if you didn't file within that 120-day window of the time frame.
And the clock starts the minute you file your first expunction petition for a conviction.
Now, I'm going to give you some examples about multiple convictions for the expunsion. So Felicia was convicted for misdemeanor larceny, possession of stolen goods, and possess drug paraphernalia on November 3rd, 2015. All her convictions count as one since they took place during the same session of court, and the waiting period is 5 years. So even though there are 3 counts for different, offenses, if they were disposed of in the same day, that counts as one session of court. So they will count as one according to the law. Example number 2, Seth was convicted for resisting public officer in 2014 and for 3 counts of disorderly conduct in 2015. Since his conviction took place during 2 different sessions of court, the waiting period is now 7 years. Now that's given the case not just with 2, with multiple. If they happen in different sessions of court, then the waiting period is 7 years from the latest conviction.
Or completion of sentence, whichever is later.
Yeah, that. Thank you, Alicia. Thank you. Example number 3, Lizzie was convicted for the hit and run, communicating threats in DWI on June 6, 2018. A year later, she was charged with second-degree trespass and harassing phone calls, but those charges were dismissed. Her convictions for hit and run and communicating threats are qualified for expunsion after a waiting period of the 5 years. The DWI cannot be expunged. It is not able to be expunged per statute. Her dismissed charges her dismissed charge is eligible for expunction immediately.
Okay, here is the process of getting an expunction. And if you become and qualify for legal aid services as a client, this is what we do for you. Obtain an accurate and complete copy of a criminal record. There are different criminal record databases. So one of them is called Cypress for short. And now certain pilot counties, Wake, Harnett, Johnson, Lee, and Mecklenburg, now use a different criminal record search system called Portal. There's also ways to obtain SBI records. And you can go to the clerk of court's offices and they have public terminals there that you can also search your record. And then we look at your record, we analyze it to current statutes, such as the ones we went over, and determine your expunction eligibility. And then there's different petitions depending on what type of expunction you're trying to obtain. There's forms for dismissals, forms for not guilty. You have to check a box. Is it district court? Was it superior court? And if it's two different courts, it's two different forms. Then you have convictions for felonies, convictions for misdemeanors. Those are their own forms, two different ones. So we have to choose the right form. We have to complete it. Certain types of the convictions for adults require additional documentation called affidavits of good character. And then there's 100 counties in our state, and sometimes different clerks of courts offices and DA's offices handle filings slightly different. So you have to figure out what their process and procedures are. And then once an expunction is granted, hopefully, then you have to verify that the expunction in fact took place, meaning the charges are and or convictions are no longer showing up on a person's criminal record, and or Department of Public Safety jail records. Okay, and then there's the access to records. So again, once a dismissed charge, not guilty charge, or conviction is actually granted the expunction and the judge signs the order, if all runs as smoothly as it's supposed to, you can do one of those record checks that we talked about, and it would say no file found. However, there are some exceptions. Here's some of the exceptions. Prosecutors can use expunged convictions. If somebody was to get into some new trouble and new convictions, they can use it for sentence calculations or figuring out if somebody has habitual offender status. And then sometimes arresting agencies may use it for investigative records, again, potentially new charges or investigations, thinking something happened. And then if you were to apply for a law enforcement position or something with higher security, maybe at a jail or a prison, then they have access to those records for their employment purposes.
Okay, I will talk about a certificate of relief. In this case, it is not an expunction. Certificate of relief can be obtained for any kind in any number of misdemeanor convictions, but no more than 3 class H or I felony convictions. Before I go into detail with that, I'd like to mention that the certificate of relief and the purpose of it, its purpose is to help people access jobs, housing, education, and other stabilizing opportunities. What it does is it creates legal protections that make it easier for employers and others to consider an entire application instead of focusing on the criminal record. So it does not erase the record, but is think about it as a recommendation letter from the courts stating that you're in good moral conduct and pretty much you're not a threat to a community anymore and things like that. Usually this is helpful when a person is waiting for their charges to be expunged. They still have to wait a certain amount of years before they're qualified to expunge some offenses, and usually the certificate of relief will be helpful in those situations. Um, it does allow for the discretion of automatic exclusions. It is viewed favorably in discretionary decisions. And again, it protects the employer from negligent hiring liability, and so the landlord as well for negligent leasing liability. It's usually very good for licensing jobs. If you're trying to get like a nursing job or a license for that, a certificate of relief, if an expansion is not possible, it would be very helpful in that case. Or any kind of like commercial driver license kind of jobs. Usually the success rate for that is very high. Let me see. And yeah, that's unless you have any other thoughts about certificate of relief, Alicia, that's pretty much the summary of it. It is helpful if an expansion is not an option yet, and it helps with in most cases.
Just a few more things. So it's important to note any number of misdemeanors. So if there's things, basically you're not eligible for criminal expunction because you have a disqualifying conviction, such for the misdemeanors, examples again are simple affray, simple assault, assault on female, things of that nature, which are class A1 misdemeanors, child abuse. You can still petition the court for a certificate of relief. And again, H&I felony convictions that may otherwise not be eligible for expunction of that conviction. But the one thing is, not all employers and not all landlords know what a certificate of relief is. So you do have to somewhat advocate for yourself and point that out. If your criminal record came into play, you would want to point out that you have a certificate of relief. If you become one of our clients, we have a handout that kind of explains and goes into more detail about these things that could help you in advocating, and you could even make them a copy of our handout.
Alrighty, go ahead, closing thoughts.
Okay. Briefly, as mentioned before, North Carolina has 100 counties, which means 100 clerks of courts offices. That's where you file your expunction petitions. The process is potentially different in different counties. Some counties, you just hand in your petitions to the clerk of court. They file them and they put them in the judge's basket. Other counties, the clerks want you or us as the attorney of record to go get a judge's signature on the petition and then bring it to the clerk of court's office. So it's important to know how it's done in the county where you're seeking an expunction. That's why we recommend touching base with them first. If you're one of our clients, we would do that for you. And so the only other thing I would tell you is you can Google the clerk of court's office. Again, it's county by county, and they're also listed on the Legal Aid website, legalaidnc.org. And in a minute, we'll take questions. I just want to reiterate, if you do want to attend another Listen and Learn on one of the other previous topics I mentioned, you can do so by registering at legalaidnc.org like you did today. Again, here's our helpline, and they have certain helpline hours. Most of them are morning, and I think one evening a week. 866-219-5262, 866-219-5262, which spells out Lance, Legal Aid of North Carolina. Please write this down if you can, or you can listen to the prompts. Expunction line to get to our intake specialist is option 1, option 1, option 2, option 3. And again, you can contact us starting in January. That's when we're gonna start assessing eligibility for new cases. So please contact us then, and we will go through the intake process to see if you qualify for legal aids, legal services, and especially in the realm of expunction. And thank you for being with us today. Spread the word. This is recorded. It'll be available again on Facebook. And if you think there's anyone that could benefit from this presentation, please mention it. And we'll do our best to answer your questions. Again, they need to be a little bit general, because please keep in mind, not only is this a public forum, but we're not going to have your criminal history or record in front of us. And lastly, if you heard, one more thing I wanted to mention, if you heard us say restitution must be paid first, there is a special form called a 415, that's a form number, that's a possibility to file, where you ask the court to waive or kind of like get rid of the restitution that you owe. It's usually granted only in certain limited special circumstances. It does require a hearing, but it's worth a shot. And especially if that's your only prevention from filing for the expunction of your convictions. Oh, and the certificate of relief usually does also require a hearing, where a judge usually just wants to know what you're up to, what your source of support is, and things of that nature.
Awesome. Thank you, Alicia, and thank you, Daniel.
Yeah, thank you.
If we're ready to start questions,
Yes.
just a reminder to folks, as Alicia was saying, if you have questions and you're viewing on Zoom, put them into the Q&A box. That'll be towards the bottom left-hand side of your screen. If you're viewing on Facebook, you can put them into the comment section below the video or to the right of the video, depending on the device that you're that you're viewing from, I should say, not asking. But you can put your questions there now. We are going to start the Q&A. We may not be able to get to everybody. We will see as time permits. And do remember that your questions must remain general. We're not your attorneys, even though, you know, Alicia is an attorney. She is not your attorney. And we need to make sure that we reiterate that, and that we cannot keep any of your information confidential. And as Alicia said, we do not have your criminal records, so we can't answer anything too specific, but we will do our best to get to you and get your questions answered to the best of our ability. So with that being said, Daniel, do you want to navigate the questions with Alicia?
Yeah, that'd be fun.
Perfect.
All right, Alicia, the first question is, hi, I wanted to see if you had a charge from a couple of years ago, back in 2000s. Wanted to see if it can be expunged from the record.
Okay, so as we mentioned in the presentation, if it's a dismissed charge or a not guilty charge, the answer is yes. The one thing we didn't totally mention is, in most of those situations, relief, meaning is mandatory, meaning the judge is not supposed to have discretion in granting the expunction. The one exception to that is if you're trying to expunge a dismiss charges where the same session of court there's convictions, the judge may potentially have a little bit of leeway or discretion. Then we have the fact that this person could have a conviction, whether it be misdemeanor, whether it be a felony, how many, and what type. So those are kind of the things we would need to analyze to answer your question more in depth.
Okay. The next question is, on a felony conviction that also has a violation of probation, if a felony is granted an expungement, would the violation of probation also be included in that, or would there need to be another petition filed? Very good question.
So theoretically, if it all works out with the clerk's office, and if not, we work on that. But yes, if a conviction is expunged and there was a felony probation attached to it, attached to the underlying conviction that was granted the expunction, it's supposed to also fall off.
Yeah.
Now, if if it was granted.
Alrighty, the next question is, with touching bases with the clerk's office, can they withhold information on how to get an expunction?
Yes, because they're not allowed to give any type of legal advice and telling you how to get an expunction, what form, that would be considered legal advice. And also, a lot of clerks, there's so many forms and so many caveats, they don't even know all of them. Expunction, petitions, they have form numbers in the bottom left, and then they have captions in the top right. And again, as I had previously stated, depending on the type of expunction you're seeking is the type of petition form you would use. One thing about the clerk's office is you can also, I forget how much it costs, but you can obtain a certified criminal record from them that may or may not be helpful for a fee. But you would want to make sure they're running statewide records and not just that particular county.
Okay, the next one says, what were the two places to find a complete background check? Is it spelled Cypress and Portal?
Cypress is CIPRS for short. Let's see, criminal infraction. I believe it's criminal infraction public record search, or
Yeah, I think you're right.
okay. And then Portal is the new online Wake, Johnston, Harnett-Lee, and Mecklenburg County public record search. And the way it's designed is it's all online. So now anybody can go to Portal, create an account, and type in a name or a specific court file number and find out what the person was charged with and what was the disposition, which is a fancy word for outcome. However, a person is granted an expunction, then you would type in the file number and it would say no record found.
Okay, this one says H&I felonies, the time limit is 7 years, not 5. I believe that the person is asking a question, not making a statement. So I guess clarify the wait period for H&I felonies.
H&I felonies, if you're convicted of one, it will, as an adult, it's 10 years. Unless it, and then multiple felonies within the 24-month period would be 20. However, they have to be qualifying and not disqualifying violent convictions. And then also, again, if it was the same session of court, it would count as one. And then with the Portal system, I think it's also known as e-filing. So you can Google like the e-filing.
Okay. How do I start a certificate of relief?
So with certificates of relief, again, it's a certain petition form. And usually, let's see, I think I had a form for, let's see. So for certificates of relief, the petition form is AOC, which stands for Administrative Office of the Courts, -CR, which stands for criminal, -273. And that's a certificate of relief petition. And then you would follow the instructions as listed on the form. And one thing about certificates of relief, raise the age, underage convictions, and adult convictions is notice is served on the district attorney's office. So they have a right to try and notify any victims that they may be able to contact to let them know that the person is filing for the expunction. This is for convictions, not dismissed or not guilties, to see if any potential objections. And again, in certain situations with convictions of, a judge does have the right to, hold a hearing.
Okay, the next question is, I have a misdemeanor charge from 1997 that keeps showing up on my record. Do I have to go back to the county I was charged in and file the paperwork in that county?
Yes, wherever the criminal charge, yes, criminal charge and conviction, which typically is the same county. The petition forms are statewide. And in the top left of the petition is where you would write in the county. Top right is the file number. Most of these petitions, they're all on the AOC website. You can also Google, if you're gonna Google, you would start with NCGS, North Carolina, General Statute, NCGS, and then the form number if you have it, or you could just do term searches. So yes, you would definitely, and then you would need the criminal file number, the type of charge, the date of offense, the date of arrest, and the date of conviction.
Okay, the next question says, I got a aiding and abetting larceny charge in 2017. It's my first charge ever. I got 12 months of supervised probation and I didn't do the whole 12 months. The judge dismissed it a few months early. Would I be able to get it expunged?
I don't have the sentencing classifications memorized. So if it was to be a misdemeanor, as long as it's not a violent misdemeanor that we listed out, and most of the violent ones are A1, or as long as it's an H or I felony, and the restitution, if there was any, has been paid, without seeing your criminal record, but just off the basis of this question, I would say as long as it meets those parameters and criteria, then yes. But again, we have to keep our information general, because I don't want to tell you yes and then you find out no, because I didn't have your criminal record in front of me to give you the best legal advice.
Alrighty. So far, the last question I see is, what is the exact date of January that you will reopen for callers? I think last year was January 6th, but I don't know if we're doing anything different.
Yeah, let's see, we're off until we come back January 3rd. I would say give us a week or
Yeah,
get caught up and everything. So possibly maybe the second week in January. And then there's an intake process. So in order to be a legal aid client, one of the criteria that a person has to meet deals with income eligibility. So our intake specialist, he has to go through a certain list of questions first to see if you would qualify as a legal aid client in general, and then also some expunction questions as well.
alrighty. So far, that's it.
And again, we also encourage people that are interested in legal aid services, whether or not it's expunction or one of the other topics that I mentioned or areas of law, that there's also an apply online button on our website. And I believe that's usually posted or available most afternoons.
Okay, one other one came in. So once we finish the Zoom, what do we have to do from there? Will someone contact us or do we have to fill out the first form?
Because we don't exactly know and get a list of who attended and who didn't, we don't have contact information. And again, this is supposed to be somewhat private. So you would call us at the helpline number, or you would apply online, and then again, our intake specialist would start the process with asking a series of questions to see about qualifying for legal aid services and expunction services.
They say thank you.
Oh, you're most welcome.
Do we have any other questions or comments, concerns, anything anybody wants to say? You can put it into the Q&A box now. I do want to throw a couple of things out there for everybody. Just bouncing off of that last question as well, to clear up any confusion, this is an informational session. And the reason that we are harping that you call the helpline is because you're currently not a client of Legal Aids, and we do want to reiterate that to you, though. We currently are not handling your case directly. In order to do so, you will have to call a helpline and be assessed for case eligibility. But we do offer these free to the public, these informational sessions, as a supplemental information on top of or instead of direct casework with us. So I hope that clears up any confusion there. Additionally, if you need to review any part of the presentation again, or you'd like to review the answer to your question that you may have asked, you can go to our Facebook page at facebook.com/legalaidnc. Again, that's facebook.com/legalaidnc. That recording of this entire presentation is going to be posted the second that we end this Zoom. So, in 5 minutes, you can log on and you'll be able to view the entire thing start to finish with absolutely no delay. And it will live there. Additionally, you'll be able to see any of our other recordings of our other topics of Listen and Learn. So if in addition to your criminal record expunction needs, maybe you have a Medicaid question, because Medicaid expansion just launched last week. So you want to see if you're eligible now under the new parameters. You can watch our Medicaid expansion, presentation from earlier this week. You can learn about simple divorce or child custody, different things like that. We offer a whole range of topics, and they're all going to live on our Facebook page at facebook.com/legalaidnc. You don't need a profile or an account on Facebook to view it. You just need access to the internet. But let's answer this last question, and then we're going to wrap up for the day.
It says, once you get a charge expunged, how long does it take for it to not show on your record?
Okay, that's a great question to ask. So theoretically, as far as your official court record, it should be within just a few days, maybe up to a week. The clerk's office is the one to process the signed expunction petitions and orders, and they're the ones that are supposed to remove your granted expunction, so your charge and your disposition from your record. And then for those processed with the North Carolina Department of Public Safety, meaning you are given unsupervised or supervised probation or an active sentence, you would also have a record there. People probably don't realize that. You can find that out by searching offender search for that. Anyways, their clerk's office and NCDPS, which is now under the Department of Adult Correction, they are supposed to communicate with one another, and your information should be removed from there as well. Sometimes that doesn't always happen or go as smoothly. And then if you're one of our clients, we have to email certain people to aid in getting those removed from your NCDPS record. Now, the other thing is private third-party criminal record providers. We call those, I think we call them ghost records. They have like a name, but sometimes they're slow to catch up, or they might just run people's records every so often. So you will have to be careful about the third-party vendors. And I don't know if you could find out ahead of time what company an employer uses for criminal background checks and do it yourself or contact that company. But once your expunction is granted, it's supposed to be gone from the records that we discussed. And to double check that, you would just enter your case file number and it should say no record found. If you got a full record expunction, then you would also, you could enter your name and birth date and it should say no record found or for your name and date of birth. Hopefully that answered that. And one more thing, I don't want to discourage anybody from trying to file things on your own, but as far as filing to petition for convictions, or even raise the age, a person needs to be very careful. There's a lot of additional documents that need to be filed with your petitions. Again, in multiple counties, it triggers the 120-day rule. With expunctions, most types of adult expunctions, you get one shot, and if things are left off or missed, you can't necessarily go back and take them off later if you realize your mistake. Again, there has to be notice to a DA's office, and the right petition form needs to be filled out in the correct manner. So please at least see if you qualify for our services so that we can aid and assist you in doing it the way that's required by law.
Awesome. Well, we're going to wrap it up there today, folks. I want to thank you all for joining us here today. Again, if you'd like to review any of the content that we learned this afternoon, you can go to our Facebook page at facebook.com/legalaidnc. And also, I want to thank our presenters, Alicia and Daniel. You guys always show up and show out. So we're very excited that you're here. And I appreciate it. Everybody have a great day, and we will see you guys in the next one.
Yes.
Bye, everyone.
Thank you so much. Thanks.
Alrighty, bye.